Massive welcome to everyone. Thank you for joining us on our final day of the Law Faculty's Taster Days. We had the first 2 days that were all in person. We had 200 people each day, all went really well. So hopefully today will be just as interesting, exciting for you all. We'll run through the schedule a little bit and just let you all know what's going on, what to expect. Okay, so first up, we have got myself doing a quick introduction, and then at 5:10 I'm going to introduce Matt Dyson, who's doing the taster lecture today on criminal law. He's already joined us, so he'll be there. If you have any questions, you should be able to raise your hand or put a reaction on Zoom and he'll be able to speak to you. Then we have Clifford joining us at 6 o'clock today as well, and we'll be joined by Gemma Mills, who's an associate. She's going to go through a little bit about how her journey into becoming an associate at Clifford, how she went through university, what options she made, if she did a law degree, if she didn't, and then kind of how her career has progressed. And you can ask her any questions about any of those steps, really, about her joining university, her choosing her degree, how that went, and then also how she got any work experience and kind of placements before she joined Clifford Chance as well. So please take this opportunity to ask as many questions as possible. And then after that at 6:30, we're going to be joined by Joseph Chu, who's a graduate student, and he's going to give you a seminar experience. It should be very interactive. He's had the past 2 days he's been doing seminars, and all the students have enjoyed it a lot, so hopefully it will go as smoothly as that. I just wanted to start off by showing you a few things about the admissions process. So although this is all about giving you a taster of law, it's also a little bit about admissions, because if you were to apply to us through UCAS, you would need to know about the LNAT test and about the UCAS application as well. Okay, so you should be seeing my Taster Day screen. So that just runs through the timetable of everything that's going on today. And I've only got 8 minutes to quickly go through everything, but I wanted to start off with the UCAS application and the LNAT. And I kind of want to tell you the key things that you need to know about LNAT that are going to help us as a university and also other universities that you apply to get your information. So first off, before you do anything, you'll need to register with Pearson, and I would need you to start that early. So the deadlines are, registration opens on the 1st of August every year, and the first test will start on the 1st of September. And this year, the deadline is the 16th of October. And I say this year because it's usually on the 15th, but that falls on a Sunday this year, so they've changed it to the 16th. So you only need to remember one date really, and that's the 16th of October, and that's the deadline for both the LNAT test to have been taken and the UCAS form to have been submitted. The UCAS form has a time deadline as well, so you need to have submitted that by 6 p.m. before 6 p.m. If it's 6:01, then it will be marked by UCAS as late, and universities do not have to take late applications, and Oxford generally don't take late applications. So once you've registered, something to consider is if you are a student who has special requirements when you do examinations, so say extra time is required or you need a larger screen, that kind of thing, you're unfortunately not going to be able to book online. You're going to have to fill in a form with Pearson and just explain what you need and what you usually get. And then they will go back to the test centre that's closest to you and will try and find or make sure that they can kind of give you everything that you need in order to sit the test as well as everyone else. So it takes a little bit more time. So that's why I say start early. Even if you don't have those requirements, start the process early, because there's only a limited number of availability for the LNAT test. You want to get one that's close enough to you so you don't have to travel too far, and those places will fill up really quickly. So I advise you to register early and book your test early. So the first test will start on the 1st of September. You'll need to, prior to that, start practicing writing your essays, start timed essays. That's kind of the biggest thing. The computer will just cut out and you might be mid-sentence. So you just need to practice a few things like that. There's so much information you can find on the internet. You can go to YouTube. The university have a channel, the faculty have a channel. There's lots of videos that have been done by students and by colleges as well, as to how to kind of prepare yourself for the LNAT, for the multiple choice section and for the essay section. Lots of good advice out there. Pearson's website also has 2 mock tests for you. So good, have a look at them. They're on the website. But if you've run out of mock essay questions, you can also look at the LSAT, very similar questions, lots of information out there on the internet as well. We also advise something called Oxford Big Question. It's a website, and it just rolls through some big questions that you could use for practicing essays and debating skills, but it's also going to come in handy if you're shortlisted for an interview as well. So there's lots of stuff you can do in the kind of lead up to doing your UCAS application. A few other things. So when you go to your test, you're going to need to take a photo ID with you. And this is really important, because if you don't have a photo ID, you will be turned away at the door. And if you've left it really late to kind of take your test, maybe the 14th, 13th of October, maybe even the 15th, the chances are you're not going to be able to get another test scheduled in time before our deadline. So again, book early, take your photo ID with you. The way that it works is that Pearson will mark your the multiple choice section and give you a score. You won't find that out until about mid-February, but we'll find it out a lot earlier, October time. And then the essay, whichever university you apply to that accepts the LNAT, that essay will then be given to that university, and they'll have to match it up with your UCAS application, and then they will run their own system on how to mark it. At Oxford, we do comparative essay marking. So it means that your essay is probably seen 8 to 10 times by different people, and you will get a comparative score through that. When we do our application process, we use your GCSEs, your predicted A-level grades, your multiple choice score, your LNAT essay score, all of your contextual information from your schools that you've been to, your personal statement, your reference. We'll use absolutely everything that we can to make a really good assessment on if you should be shortlisted for Oxford. There's a few other things about choosing colleges and things like that, but I just want to kind of get the key areas over for you to kind of take notice of before we start the taster lecture. You'll see this on all of my social media in the run up to the LNAT. Are you taking the LNAT? Are you applying to Oxford? Tick this box. So this is to do with the registration. When it comes to registering, you'll be asked, and it'll be this really small question. You should tick the box of any universities you're thinking of applying to. You must tick at least one. But what it actually means is you need to tick the box of any university that you're going to apply to, in every university you're going to apply to that is on that list. Ticking that box means that university then has the authority to access your Pearson LNAT information. And that means that me as administrator, I can go on, export everyone that's ticked the Oxford box, and that should be everyone that's applied to UCAS. The issues come along where I need to match the UCAS application with the Pearson LNAT information, and some of that information is wrong. So say you haven't ticked the box, you won't even be on my spreadsheets. Big issue. So for us, it looks like you haven't taken the LNAT. So really, really, really tick that box. The next thing that could be an issue is your UCAS ID or PID. Because the UCAS application and the LNAT run at the same time, you may not have your UCAS application number by the time that you're registering for the LNAT. So that's fine. Just put in all zeros. Don't make up a number. Just put in all zeros, and that will make it a lot easier for me or any other university to match your information. You can definitely, and you really should, go back once you have your UCAS ID number, and before the 16th of October, go back into your LNAT registration link and change your UCAS ID, update it so it's the right one. And that will just make it so much easier for all the universities to link up your information. You need to use your passport name on your UCAS form and on your Pearson registration. If you use your official passport name, then I will be able to link everything up easily, and your LNAT scores will come across to university with ease. It's if you use a name that is not registered to you, or say that your preferred name, that then will cause issues when we come to match the information. So that's kind of key as an administrator here. I'm just trying to throw it out there to make it as easy as possible, but also to make sure that we get your LNAT information. And I'm going to hand you over to Matt Dyson, who's going to do a talk on criminal law for you.
Hello. Hopefully you can all hear me clearly. So thank you, Emma. Very kind of you to do the introduction and also to give them that very important information about some of the technical parts of the application process. So I'm going to be talking about criminal law. The title, so to speak, is Criminal Law, a Gourmet Tasting Menu. And what I'd like to walk you through is examples of the different parts of criminal law that you would cover in your first year at many universities, us being one of them, just to give you a flavor of the kinds of issues and the kinds of reasoning processes we use as part of a criminal law course. And that's a bit of an example about what you do in law courses more generally. And now time is very short. Normally, the kind of material I'm talking about here would be 42 hours worth of lectures or something like it. I don't have that kind of time with you. If I'm lucky, I've got 45 minutes. I would like to be able to engage with you as well, as Emma said. So you can try to get my attention with chat comments. But I think the reality is we'll hold on to the end if we can. But if you haven't understood something, please do ask, and I'll try to help as we go through. So the first thing I'd like to talk to you about is number one on the handout, which, as I say, you'll ultimately get, which is about emissions liability. Now, emissions liability is one part of what we might call physical components of an offence. So when we describe what a crime is, we tend in this jurisdiction to talk about what you've done, the physical component. Sometimes we use a Latin tag, actus reus, and the fault element or culpability standard, or sometimes mens rea. Essentially what you've done and why it was blameworthy that you did it. Focusing for a moment on what you've done, there are lots of interesting aspects of this. Most of them are describing conduct, result, or states of affairs. Most of these focus on conduct, so what you do, or result, things you bring about. There is a small category of states of affairs. These are not things we normally criminalize, though sometimes we do. An example would be immigration matters. It is just a crime to be here without leave, without some sort of lawful reason. And it may well be the case that you didn't have a great say in how you ended up here, but it's technically a crime to be here. These kinds of situations are quite difficult to justify, and they are thankfully relatively small. So if we focus instead on the conduct and result crimes, conduct crime, something you've done, a result crime, an outcome you've brought about. You've probably thought of easy examples of this already. A result crime like murder, you've caused the death of a human being. There are other famous examples as well. Sometimes it gets a little bit confusing whether something is something you do or a result. So theft is an example. You might imagine that theft was about taking somebody else's property. But in fact, the way we define it, we focus on the acting as owner over another person's property. So it's more how you act, it's something you do, even if we normally in everyday life think about theft being the loss of your own property, a result. But what about an example of another conduct crime that's a little bit easier? Well, one of the simplest examples is a driving offense. Driving dangerously or driving without care and attention, now careless driving. That's what you do. Nobody need be hurt. There might be no outcome. It's simply something you did. But all of these revolve around what we're doing or bringing about. And the implicit idea is that this is something you've done, an act. But it's also possible that you'll be liable for something that you didn't do, or put another way, you should have acted and you failed to do so. An example of this is a situation where the law requires you to do something, like an act of parliament. For instance, if there's a road traffic accident where somebody is injured, you are required by law to report it to the police. And if you fail to do that, you're liable. Even though it wasn't something you did, it was something you failed to do. So those kinds of statutory examples are just one example, and there's lots of groups of those. And there's other kinds of places where this happens. The law might impose special relationships, parent to a child, or it might say that once you've started to do something for another and they've become reliant on you, you must carry on or make alternative arrangements. The kind of situation is where you're looking after someone who's very sick or vulnerable and can't look after themselves, and you just suddenly stop and they're reliant on you and then they suffer harm. You could be liable for that. There are some situations where a contract might impose a responsibility on you to act. So if it was your job to, for instance, raise and lower a manual level crossing for a train, the idea being that if someone was trying to cross the crossing when a train was coming, you would have lowered the barrier and they would know not to, and indeed physically do so. There, it's your contractual obligation and you failed to perform it that could make you liable inside the criminal law. But the last category, and the one I want to quickly talk to you about, is about a different kind of situation where you might have, in some sense, been responsible in the broadest possible way for why there was a danger, and therefore we say you should act. So if I arrange a situation where there's a boulder that's hanging above your head, and if you make too much noise, it will fall on you, you might say, well, it wasn't me who pressed a button that released it. It was just me failing to save you. But that wouldn't be very persuasive because I've created the entire situation. That's not really what we're talking about here. But what we are talking about is a reason why you might not be liable initially. You might not be guilty of something at first, but you were supposed to do something later because of what you started. And the case I want to tell you about is a case called Miller in 1983. Now, this particular point in time, the relevant offense is still the same, criminal damage, in this case, damaging by fire, but there was a different idea of culpability at this point in time. So just accept what I tell you when I say that you are liable in 1983 for the offense of criminal damage if you intended criminal damage, or if you foresaw the risk, or a reasonable and sober person in the same circumstances would have foreseen the risk. Now, the law has changed since then, but that was the test at that point in time. So a homeless man goes into a house, he lays down on a mattress and has a cigarette in his hand. He falls asleep. He wakes up a little while later, seeing that the mattress is now starting to smolder because the mattress had the cigarette land on it. He wakes up, moves into a different room. Sometime later again, he wakes up a second time and goes to see that the house is basically starting to burn, and he leaves. Now, at the point that he was lying down, the prosecution couldn't prove that he was conscious as the cigarette started to set fire, or at least cause to smolder, the mattress. If they could prove that he'd done that consciously, well, a sober and reasonable person would have been aware of what was happening, seen the obvious risk, and would be liable under the 1981 Criminal Damage Act. But the state couldn't prove that he was conscious when that happened, and so he wasn't responsible for something that his body did when he was unconscious. But what they wanted to say was, well, when he later woke up, he must have realized that he was the cause of the damage to the mattress and the fire, or at least the smoldering parts of the mattress, and he then was obliged to do something about it. So this is a really interesting way to expand the situations when we're liable for something we didn't do, for failing to do something. And it's really interesting because at the point he set in train these events, we must assume he was unconscious. It hadn't been proven otherwise. So how many things should we be responsible for that started when we were unconscious? How many things can we restrict people's lives about? So one of the logics behind the act and omission distinction, as we see it in our law today, is that if we require people to do one thing, we greatly restrict their liberty. There's very few things you can be doing at any one point in time. But if we say, don't do X or Y, don't harm people, don't damage their property, there's loads and loads of things you can do. You just can't do these narrow things. But liability for omissions is the reverse. You must do at least this one thing. Is this an infringement on the autonomy individuals should have in our state? Does it go too far? Well, that's the question that I'm posing for you in the law of omissions. Now, I'm going to turn to my second example, and this is the law of intention. So we're now going to look at the culpability component, why we blame people for doing something. There are many ways that we might find culpability in our law. We might say, you took a risk you shouldn't have taken, like we just heard before. We might say, you didn't take the care you should have taken. The most extreme form, we commonly think, is that it was your purpose to do something that was prohibited. So, famous example, murder in one form is you intend to kill a human being and you kill a human being. That is the most culpable way that you can end another's life. It's your purpose to do something which the law says you should not do. Not just you're taking the risk of it, not just you're not taking enough care to prevent it, but it was your purpose to do this prohibited thing. But then you might wonder why intention is such an obvious term and what it means. And English law doesn't give a definition to it. We routinely just ask a jury or a finder of fact like a magistrate, are you sure that the defendant intended, for instance, to kill? We don't give any definition of what intention means. We treat it as if it's an everyday word that people should understand. That might not always be true. And there are some rare situations where the law does accept a special direction should be given to the jury. And this is where intention doesn't quite mean purpose, which is what we normally think it means. I'll give you the example. This is from a case called Woolin in 1999. So a man throws down his small child, basically a baby. There was no evidence that he was trying to kill the child. That was not his purpose. It's not something he would have wanted or desired, and certainly not something that was his objective. The jury were told, based on the then House of Lords, now it would be the Supreme Court, but our highest court at the time, the House of Lords, said the test should be that a jury would normally be given the simple instruction, did the defendant intend something? If you really have to give more, you can say that this is something along the lines of, was it your purpose? But in the very rare circumstances where purpose doesn't capture the kinds of facts you're dealing with, a jury may, but do not have to, may find that where a defendant foresaw something as virtually certain, and it was virtually certain, and carried on, that he intended it. So it's a way for not purpose, but thought of likelihood can be equated. So a jury has this choice. They could decide that it was virtually certain, that the defendant foresaw it as virtually certain, but it did not count as equivalent to a purpose. Or they could decide that it was virtually certain, it was foreseen as virtually certain, and that is equivalent to purpose. This is the only situation where we give anything meaningful about what intention means. Now, I should say, this does not get used very often. In fact, I've only found about 27 cases since 1999 where any court has been reported as applying or considering this definition. Now, when you think about it, there's something like 1.5 million criminal cases a year. To only find 27 reported cases, that's not very many. So we seem to get by without using this Woolin direction very often at all. Third, I'm going to talk to you about homicide. Now, I've already mentioned murder, and the most extreme form of that is killing and intending to kill. There is another form of murder, though, all under the same category, called murder, intending to cause serious harm and killing. So murder is killing a human being, intending to kill, or intending to cause serious harm, grievous bodily harm. This means that if you have a fight with somebody who you would never wish to kill, and you do intend to break their arm, knock them unconscious, any of those would be enough if by some reason they die for you to be a murderer. So murder is actually quite a broad category in our law. But below that, there are things we call manslaughter. This tends to mean any killing of another person, either where you did intend to kill, but for some reason we recognize you as being less culpable, and we call that voluntary manslaughter, or you didn't intend to kill, but we nonetheless hold you responsible in respect of the death. So the gross negligence manslaughter or unlawful act manslaughter. If you're in a tussle with somebody you never would have any MR about, no mental state about causing them anything, maybe not even any harm at all, but certainly not serious harm, you can be liable even when they die, called unlawful act manslaughter. But the one I want to pick up on is a form of voluntary manslaughter. So you do intend to kill. And so the entry route here is you're liable for murder, but you're raising a defense. So you intend to kill, you do kill, or you intend to cause grievous bodily harm, and you do kill. But the law says there's some reason why you are less culpable than someone who doesn't have this special reason. And it goes like this. You were provoked to lose your self-control. There was a qualifying trigger, and a reasonable person of the same age and sex might have done the same thing. We often put the first two together. So you were provoked to lose your self-control. There was a qualifying trigger, which is actually quite narrow, And then we ask, well, it's not just that angry people have killed, it's that a reasonable person, same age and sex, and with a reasonable person's level of self-restraint might have done the same thing. That's the test. It's covered by a piece of legislation called the Coroners and Justice Act 2009. The outline is in section 54. And then section 55 defines what a qualifying trigger is. I don't actually want to focus on this much. Essentially, a justifiable sense of being seriously wronged or a fear of immediate violence. Those are the two routes. Now, ignoring the immediate violence kind of component for a moment, just focusing on a justifiable sense of being seriously wronged, there's another provision in the Act in section 55(6)(c), which says that sexual infidelity cannot be a qualifying trigger. Now, I don't want to go into what exactly this means. I don't really want to talk about sexual offenses in this context, but what I want to raise is I don't really know how this works well, and I don't know for three reasons. The first reason is I don't know what sexual infidelity necessarily is. Now, before you all giggle amongst yourselves, I have some broad idea, but I don't know exactly what it means. And since this is a criminal law and people's liberties might be at stake, the power of the state is being used to compel individuals and punish them if they fail. It should be clear. So, of course, we might accept that a couple who are avowedly monogamous, agreed never to have sex with anybody else, if they break that rule, that might be sexual infidelity. What about a couple who haven't had sex yet, but agree that they're not going to have sex until some future date, and one of them has sex with somebody else? Again, that might sound like it. But does it have to include sex? Could it include something less, like kissing someone else? Could it include watching pornography? They'd had an agreement not to do so because it's exploitative and abusive, and then one of them does it. Is that sexual infidelity? What if it's my best male friend and I have an agreement that we'll never date each other's exes? I break up with somebody, and then my friend starts dating my ex. That's something to do with sex, and it's something to do with fidelity. Is that sexual infidelity? I don't know, because the Act doesn't tell you. So that's one question. What is sexual infidelity? We don't know. Second point, why is this the one place where juries cannot be trusted to make their own decision on whether or not the defense should apply? Because the only reason you would exclude it as being a qualifying trigger is because you think a jury might accept it and you're saying they shouldn't. But why is sexual infidelity the one thing that apparently juries, lay people up and down the country don't understand in the way that we think they should, the way that Parliament says they should? Why is this the one thing they don't get? I don't understand why. They can understand everything else, from fraud to abusive behavior. They can understand everything except sexual infidelity, apparently. And the third problem is I don't really know how you apply it in practice. There are some situations where the idea of the infidelity and the other facts just merge so unpleasantly that I don't know how you separate them for the purposes of a jury. There is a particularly horrible case of a man who comes home to his houseboat to find his wife and best friend having sex on the sofa, and he flies into a rage and kills them. Now, obviously, there's infidelity from the wife. There's infidelity, I think, possibly from the best friend, and it relates to sex. But in the background, there had been a family tragedy that had happened on that sofa a year before, where a family member had been found dead. And what seems to have happened is the man had turned to alcohol and he came home drunk, and the wife had turned to other places to try to forget the pain and suffering that she'd been through. So in that kind of situation, how do you tell the jury everything except the sexual infidelity? I'm not really sure how you separate it out. Do you say that two random people were having sex on this sofa? It's unclear to me how you can explain that set of facts to them. Okay, so that's the example of an area of law where I don't think the law is entirely clear to me. You might have understood it. I don't really understand how some of it works. It's an example where something has been legislated. This was only in 2009. It's not that long ago. And when it was passed, there were claims being made that this will dramatically improve our law, that this brings certainty, it balances the criminal justice system. And those kinds of claims are being made repeatedly. The next example I want to turn to is actually using a word from the Sexual Offences Act 2003, but I don't really want to talk about the sexual offences part of it. It's the word touching. So there's a particular offence of touching somebody in a way that's sexual and without their consent, and it's a criminal offence. And I just want to use the word touching for a moment and just think through, what does touching mean? So one easy example is I have a hand, somebody else's hand touches that. Fine, easy. I think you would probably all agree with me if I say that grabbing somebody's clothing, so not touching them, that would also be touching, but not touching their body, but it would be touching because the clothes are associated to them closely enough. Then, of course, we have other problems relating to touching, perhaps if it's through something else. So if I pick up a pen and I touch their hand, if we accept this, we probably accept that. Do we accept throwing the pen at a hand? So does that mean I'm touching the other person when I throw something at them? Okay, let's keep going. What if I'm not going to do this because this is like my personal space, but if I threw some water and it touched the other person, would that count as touching? And the question I have for you is, if I use a jet of air from a fan and blow the air onto somebody such that the air reaches them, is that touching them? Now, I'm not aware of a case that's actually decided the matter, though I was discussing this case with a criminal judge just the other day. At what point in that chain from skin to skin to shirt to pen to et cetera, down to blowing a jet of air, at what point, if anywhere, do you decide that's no longer touching? And here's a reminder then that the criminal law is often about, as much of the law is about, defining important concepts and describing rules which help to make society fair, just, equal. Now, in this particular situation, there is an offense which turns on touching. Do you think controlling a jet of air against somebody would count as touching? My next example is from the inchoate offenses. This is a part of the criminal law which deals with incomplete offenses, which doesn't mean what you think it means necessarily. There could still be some harm. There could still be something we would regard as wrong. But in a way, the harm we're looking most for, the bit that we're worried about most, hasn't happened. So an attempt, a conspiracy, or encouraging another to commit a crime. So attempted murder. I've tried in some sense to kill you. The test for this is governed by a piece of legislation from 1981. And that piece of legislation says, if you do acts which are more than merely preparatory, then you've done enough. And you have to be intending to commit the offense. So you pull out a gun, you pull the trigger, the gun misfires, it doesn't shoot, and the other person survives. That would be an attempt. But just buying the gun, planning in 2 weeks' time to go and kill them, is probably not more than merely preparatory. But the one of this I want to talk about is conspiracy. Now, conspiracy is defined by a piece of legislation from 1977 called the Criminal Law Act. There's a few different kinds of conspiracy. This is the statutory form of conspiracy, the one that is based on this act, and it is the biggest, largest category. Section 1.1 of the Act says, essentially, that a conspiracy is an agreement between two or more persons, you must have at least two, to a course of conduct which, if carried out according to their intentions, would amount to a criminal offence. If we shorten that just for present purposes to agreeing to commit a crime, then you get the idea of a conspiracy. But my question to you is, why is that criminal? And you might say to me something like, well, it makes it more likely the crime will happen. Or you might say it allows us to intervene earlier. If I said that Emma and I agreed that in 30 years we'll kill Bobby. I haven't checked if there's a Bobby in the room. If there is, you're pretty safe, just so you know. In 30 years, we'll kill Bobby. Does that meaningfully make it more likely? Does that bring that any closer in any normal sense? I think the argument would be no, it doesn't. But we criminalize conspiracies. The mere agreement between two persons or more to commit a crime is itself a crime. So if I've decided to kill Bobby, that could be a lot closer than if I've agreed it with somebody else. And yet just deciding it isn't itself a crime. You'd need to go as far as the attempt, more than merely preparatory acts. Whereas when Emma and I make this agreement, we're not going to do anything about it for at least 30 years. Well, 29 and a bit years, we won't be doing anything about it. And yet we criminalize that. So my question to you is, why do you think we criminalize conspiracy? Why is this a thing that we should make? Why should we criminalize the agreement? So my next example, I'm going to turn to complicity. This is a part of participation. So the parties who are engaged in a criminal offence. One of them, at least, will be the principal, the person who is bringing about the relevant components that make it a crime. Other people might be co-principals, or they might be accessories, those who assist, encourage, or procure the principal in the principal's crime. There's a lot we could go into here. It's a huge area of law. I have the honor to do 6 hours of lectures on it, as well as a number of tutorials. But what I want to ask is essentially, when have you done enough to be responsible for another's crime? And what kinds of mental states show that you're culpable in respect of another's crime? That's the questions. Responsibility and culpability. When are you connected, responsible and culpable for another's crime? Now, there was a new piece of law on this decided by the Supreme Court in 2016, a case called Jogi. Cards on the table. I was involved in this case. I don't think it was the perfect outcome, but I think it's a very significant improvement, but some people disagree. Prior to Jogi, there was a special rule for deciding responsibility and culpability where more than one crime was in play. It went like this: we will make it easier to convict you where you commit one crime out of which a second arises. We'll make it easier to convict you of the second crime. So the scenario given is most commonly a robbery. You're committing a robbery with somebody else. And in the course of the robbery, the principal, the other person, kills a security guard, a bystander, someone. Now, if you would be liable directly as a secondary party to that homicide, you had to assist or encourage or procure. You'd have actually had to do something in respect of the victim, or you would have needed to have that second crime as part of coming out of the course of the first. But you can see how to be a direct secondary party to it under the normal rules, you'd have to do something towards it. And you'd have to intend to assist or encourage the principal in respect of that crime. Whereas under these special rules, which existed till 2016, if it was part of what we called sometimes parasitic accessorial liability, the second crime was a parasite on the first, you need only to show that the second crime arose in the first. You need not show that the second crime was one you assisted or encouraged. And you need only show that the secondary party foresaw the possibility, not intended to assist or encourage, but foresaw the possibility of the second crime taking place. So on the one hand, if you were the one who did it, let's say it's a murder, you'd have to intend to kill and you'd have to kill, or intend to cause grievous bodily harm and kill. That's one possibility. If you were if it was a crime you were immediately assisting, you would have to assist or encourage it, actually contribute towards it, and you'd have to intend to assist or encourage. But if it was part of this parasitic accessorial liability, you didn't have to contribute towards it in any way. It just had to arise in the course of the first crime, and you need only foresee that it might possibly happen. So a much lower standard, both lower than the principle and lower than normal complicity rules in the case of one crime and coming out of a second. Now, we got rid of those rules in 2016, but they're an example of how we understood the criminality involved in helping another to commit a crime differently in different contexts. So the question for you essentially is, do you think it should make a difference if the crime is being committed in the course of others, or whether it's just the first crime itself? The next example I want to quickly take you to is the rules on intoxication. So English law takes a particular position on whether it should be easier, harder, or make no difference in convicting you based on whether you're intoxicated. So we could have different moral and political positions on this. One of your housemates comes home and they smash a vase and they come home drunk. Do you think it should be easier to establish they've done something wrong because they were drunk? Should it make no difference, or should it be harder? Should you say something like, oh, well, don't worry, they were intoxicated? And I know that there are some who essentially want to be intoxicated enough when they go out drinking and dancing of an evening in a nightclub that they want to be able to say the next morning, oh, I did this, tried to kiss somebody, did this particular dance move. Oh, but I was so drunk, I didn't know what I was doing. Alcohol provided some sort of excuse for them. But others might say, well, you know you do this when you're intoxicated. It's your responsibility not to get yourself in that state. And more people, again, might say it doesn't make any difference to us whether there's intoxication or not. I don't want to go into all the rules for this. Most of the time, the jury and the magistrate, when deciding this kind of question, just decide whether you had the relevant fault and there's no particular problem. But there is an interesting case around someone who is involuntarily intoxicated. I don't want to talk about the facts, they're pretty unpleasant, but imagine there's a person who always wants to do something that society says, and I think pretty much everyone would agree, would be wrong. But he always stops himself because he appreciates that it's wrong. It's something he desires to do, but would never actually do, and never in his life has he done it. Now, someone comes along and wants to know something about him for business purposes, wants to have an advantage. So they hire a private investigator who finds out about this man's desires and gives him a very strong drug, a drug that disinhibits him. So his ability to stop himself doing something he wants to do disappears. The private investigator then puts him in a room with a video camera and with the person he would like to do it with. That person is also drugged and does not consent. Now, the question becomes, should you be liable when you were involuntarily intoxicated, someone intoxicated you, for things you do in that state? English law said yes. If you had the relevant mental state, it doesn't matter how it got there. Sometimes paraphrased, somewhat imperfectly, but memorably, as a drunken intent is still an intent. Do you think that's right? Turning to my 8th and penultimate example, general defenses. So here I want to just quickly give you an example. I won't go into the details of the case, but of self-defense, and indeed mistaken self-defense. So do you think the criminal law should say that the test for self-defense is whether you were truly under threat and then force used proportionate to the threat? So for example, I'm walking down the street, somebody pulls a knife on me and says, "You're going to die, punk." And I punch them hard enough that they're seriously injured. So there was an actual threat of death. I use force, less force than death, but serious force. That would seem to me to meet the test. But what if I make a mistake? And it was actually a friend of mine who was playing a practical joke, and in their hand, but which I hadn't seen clearly, was actually a banana and not a knife. And they thought they were putting on a tough guy voice, and they say, "Die, punk." And they planned to follow that up with, "If you don't eat more potassium." But I didn't let them finish, and so I punched them in the face. Now that's not an actual threat to me. Can I still use force? And let's just accept that the force is proportionate, at least to the threat that I perceived. So can I use mistaken self-defense? Do you think English law should permit that? Or if I use what I think is self-defense, but actually I'm not under threat, should I be liable in full for any harm I cause? If you think about that for a moment, I'm going to make it even harder. Could you use force against someone who isn't actually threatening you, but because they are indirectly allowing a different party to threaten you? So imagine you're at your friend's house. Your friend is also a buddy of someone who wants to harm you. So your friend B, you're staying around B's place. C knocks on the door. You know that anytime C comes close, C tries to attack you and can really hurt you. And B knows this too, but B thinks that B will be able to keep the situation under control. And you say to B, "Don't let C in, don't let C in." Can you use force against B to stop C being able to harm you? So B is innocent in this scenario. Can you use force against an innocent person to protect you against someone who is a threat? There are some further examples that we could go into which start to get beyond self-defense and into other difficult questions, like whether there should be a general defense of necessity. You might not have heard of the Zeebrugge ferry disaster. But there's a story that someone during this ferry disaster froze, and that risked harm to other people, though not directly because that person was attacking them. The story went like this: a sinking ferry, a ladder to get out. Someone above you on the ladder freezes in terror and can't carry up. There's no way to get past them. And so you all below would die in the water as it rises. Can you push that person off the ladder in order to let everyone else get out? That person isn't directly threatening you, but on the other hand, their existence there in the frozen state means that you're at risk. So that's extrapolating beyond self-defense and into something like necessity. That's my penultimate example. My last example to you is from the law of theft. The simple way of asking this question is to say, can you steal from another when the other gives it to you willingly? Sounds like an easy question, right? So let's imagine, for instance, that you've lied. So we know you're dishonest, which is one of the requirements of theft. We know you're dishonest because you've lied. And you're asking someone for £5. So let's run this again with Emma as my example. Emma says to me that she wants this £5 note, and she wants it for something acceptable. So she wants it to buy a book, to buy some pens and paper, all the things that obviously I as an academic am very much in favor of. I know Emma, and I know she really wants it for something not so acceptable, but not inherently illegal. So let's say alcohol as an example. So she wants it for that purpose. So she's lied to me. She's dishonest. But I know Emma. By the way, Emma's amazing. But let's just say for this purpose, I know Emma. I know she's lied to me, but I want to give her the £5 anyway. Can she steal it from me even though I give it to her with my consent? Now, I would love to pass this through the computer to her, but because English law says that she can steal it even though I give it to her willingly, I can't give her this £5, much as I'd like to. Now, why does English law say that? Well, there's a case called Hinks in 2000. Essentially, a woman met a man who had very low IQ, but was also a very generous and kind man. She would essentially say to him, oh, can I have some money? Can I have a painting? Can I have a TV, etc.? And he would say yes, and he would give her these things. They were valid gifts. They were not gifts which she obtained by fraud, by lying. They weren't gifts which he was unable to give because he had too low an IQ to make valid gifts, which is a possibility, just wasn't what was happening here. And there wasn't undue influence. She wasn't emotionally abusing him. So they were valid gifts. And so the criminal law ultimately decided that she was stealing them, even though he gave them by his consent, because she acted dishonestly and acted as owner over them. So they looked at the Theft Act 1968, Section 1.1. A person who dishonestly appropriates, acts as owner, over property belonging to another, intending to permanently deprive the other of it, is liable for theft. And they decided that consent wasn't important to whether or not there was an appropriation and acting as owner. Now, it could be relevant elsewhere. It could be relevant to dishonesty. So if you believe you have the right to the goods, then you're statutorily not dishonest. But it was essentially accepted that the jury would have found her dishonest. Now, those are 9 examples to you of the criminal law, right? It's only a very brief taster of all the things we could be covering inside the criminal law scope. What I've tried to show you is some examples of places where we have a rule, and I'm not sure how it works. I'm not sure it makes sense. Places where it's not clear we have an answer yet, like whether air constitutes touching. Places where we have a rule, but I wonder whether you agree with it. And places where we expand into the future, asking about, well, what could the rule be going forward? What happens if we have a drug which doesn't just disinhibit you, but it makes you feel something, like a slap on the back of your neck, a little pinprick, and it gives you anger instead of just making you disinhibited, and you go on to kill someone? are you liable for murder? Because at the point you acted, you did intend to kill, even though you've been involuntarily intoxicated. So this is the kind of thing that we cover. Yes, you've got to know specific pieces of information, right? You've got to know facts, sure. But most of what we do is not just rote application of existing ideas, regurgitating facts. It's about trying to work out sometimes what the law was, what the law is now with new fact patterns, uncertainty, what the law will be in the future, and also what it should be. What's the best answer? How can we make a society as fair, equal, and just as possible? And criminal law is just one part of that. So I've been talking for about 40 minutes, and I've attempted to give you this broad outline. I did say I'd try and keep some time towards the end for any questions. I'm not quite sure how the best way to do that with 160 people in the room is, but I'm very open to try. Emma, do you have any ideas?
I'm also really hoping that I've set up the Zoom properly, because I can't find the chat anywhere. So I'm hoping that they can just raise their hand and then be able to turn on their mic. Do you want to try it with anyone? Does anyone have a question out there that would like to raise their hand? And then we'll try your mic. Fingers crossed it works.
So if you look under reactions, you'll find recognize hand gestures, and that should give you a chance to raise your hand. Somebody did do it earlier in the
did they?
In the session. So yes, I can see Emma White clapping.
Oh, that's not me though.
A different Emma White is clapping. Now, I don't know if that's hand raising or clapping, because I'm not sure if that's the only options you have. But Emma White, if you wanted to say something, now's your chance.
Yeah. Tasneem, I think that is.
Yep, it is me. Hi.
Oh, so you can turn your mic on. Awesome.
I can turn the mic on. Yeah, it is
okay.
Me.
Hello,
Hi, Matt. Hi, how are you? I was just checking.
Great. Lovely to hear from you. Right. Well, we've established that works, people.
Yeah.
So one of our other fabulous members of staff has just demonstrated it works. Wonderful. So we've got what the name that appears for me is Ritzirio Chung, or that's my bad way of pronouncing it. Ritzirio, do you have a question?
Yeah, talking about the Hinks case, how can you deprive someone of their property when they willingly give it to you? That's what I don't really understand about the case.
I follow, but I'd struggle to explain how you deprived somebody of something with their consent, though I think it is possible to, the word deprive could mean that. The snag is, the definition under the Act is appropriate, not deprive. So the question is, what is appropriation? Our courts have defined it as acting as owner. So you could act as owner over property, even though you do so with the consent of the actual owner. It's interesting, you can do so even though you don't even touch it, for example. So let's imagine I have borrowed Tasneem's phone, and I say, who would like to buy this phone? Well, I'm touching it. But let's say it's on the shelf over there, and I point to it, or I show you a photo of it and say, who would like to buy this phone? Well, I'm acting as owner over the phone, even though I don't touch it. So I think the answer to your question is, yes, there's quite a lot of problems in the background about what it means to act as owner, even though you have the consent of the owner. There are some problems, but at least a matter linguistically, you could act as owner, even though you have that person's consent. Does that help you at all?
Yes, thank you very much. That clears up a bit.
Well, not perfectly. There isn't a great answer in English law. Any other questions? Is there anyone else I can help? Mustafa Selik or Kelik?
Yeah, it's Selik. Can you hear me?
Yes, perfectly.
Okay, so in the case of murder in self-defense, how does that function? Because in law, for example, in the States, it's illegal to murder somebody in self-defense.
So I don't specialize in US law, though I don't entirely recognize the statement you just made, but let me at least explain it for English law. If you kill somebody, if you satisfy the parts of murder, kill somebody intending to kill them or intending to cause grievous bodily harm, but the reason you did so was, let's say the test is in English law, an honest perception of the threat and reasonable force in proportion to your perception, then you don't commit the offense of murder. So though you've complied with the parts that murder is, we then recognize a general defense of saying self-defense. And so you're not liable for murder. So it's not that you're murdered somebody and you get a defense. You didn't get to the point where we call you a murderer. Now, what is true is that many common law legal systems don't recognize necessity as a defense to murder. So if somebody isn't attacking you, most countries in the common law tradition would say you can't kill them for your benefit. And so there's a famous case of Dudley and Stevens, where some men were shipwrecked in the 19th century and they killed the cabin boy and ate him in order to survive. And they wanted to say, well, this was some sort of necessity. We had to, otherwise we would have died too. And the court wouldn't accept it. There was no self-defense in that situation. And they tried to argue there's a general idea of necessity which justifies it, which probably explains some of self-defense, just didn't apply. Does that help you at all?
Yeah, absolutely. Thank you.
No worries. I've got Ruby next. Doyle.
Hi, can you hear me okay?
Absolutely.
Perfect. I just wanted to ask if there were any kind of books on the definition of intention in English law that you've like kind of personally read that you would recommend to learn more about it.
Well, I've written a book, or no, I mean, I have written a book which addresses this, but the snag is there's lots of different perspectives you could come from. There's a purely sort of trial process one. There's one that you would teach students, and then there's another one about research. There's also lots and lots about theory, about what it should mean, and whether or not taking a risk of something that you thought was very likely is in any way culpably different to having it as your purpose, or just not caring. So if I cycle along the street, cycle incredibly dangerously, and it's not my purpose to hurt anybody, I just don't care about anybody else, is that as bad too? So there's lots of different sources on this. And I can't recommend one in particular. If you were to study law, or if you were at university and so you had access to a law library, it doesn't have to be through studying law, there are lots of books you would study. There are lots of resources you could go to. I would probably then suggest one of the standard criminal law texts and look in the footnotes and go from there. So for us, typically that would be either Smith, Hogan and Ormerod or Simister and Sullivan. And in the footnotes, you would find references. There are other books about it. Anthony Duff has written quite a lot about it. There's actually a collection, I don't think you can see them, but some of the stack behind me is all about that kind of thing. And there's more in a box down there. So yes, Anthony Duff's written some good work. Andrew Simister's written some good work. Leo Zybert has written some good work. There's quite a few people, Ruby. I'm sorry, there isn't a simple, easy access book, no.
Sorry, I know that was quite like a big question, but yeah, thank you. I'll read through a variety.
Great, thanks. I'm running out of time, but I've got Lily S.
Hi.
Hiya.
So I want to ask, so the questions you're raising about should you be liable for being unintentionally intoxicated and can you steal from one when they give it to you willingly? Have those questions arisen because of the ever-changing nature of the law, or have they always been ingrained into law and just never actually been answered?
I actually want to go for not answer A or B, but answer C. It's a mix of lots of things. So some of these questions have been asked and we have answered them. We then might change our answer, or we might change what we think the question is over time. So we have had answers to some of these things over time. Even the definition of intention, at some point in time, we had something a little like a definition, though I would say we've never had something very detailed. It's true that there's all kinds of interesting questions about whether we change or whether the law changes and whether the law matches society or not. Like many people believe a law matches the society in which you find it. But the problem there is there are plenty of times a dramatic change in a society has not been matched by changes in its law. So even during Nazi Germany, when one would say that the Germany of the early 1940s was very different to the Germany of the 1900s or 1920s, nonetheless, a lot of their law was exactly the same. And even during periods of communism, when the legal system would change quite significantly, you would have imagined some parts of it stayed very similar. So I suppose I'm saying the question's a really interesting one. It's got a lot of places to explore it, but I would say it's a mix of both ideas, both that we have some answers and we decide that we want to change, and also sometimes we don't actually fully answer the question and often then do something else instead. So we reduce the importance of the question by looking somewhere else.
So if someone was involuntarily intoxicated and like committed a crime like drunk driving or something, but surely that wouldn't be their fault then. So who would be convicted? The person that intoxicated them?
Yeah, that's really interesting. So there's different ways we can look at this. So I think underlying your question was, you shouldn't be liable for a crime if it wasn't your fault. Now, and that's a perfectly understandable position. Actually, a huge part of our law doesn't take that position at all. So the drunk driving offense, it doesn't matter why you were intoxicated. It's just irrelevant to the law. Now, the other offenses, though, so murder, for instance, we might really care about it. But there are some offenses where we just written them in a way where it doesn't matter why. You could be completely faultless in the way that you would, for the reasons you were intoxicated and driving. You could have done a breathalyzer test. You could have had the police do a breathalyzer test, which says you're clear, and then you drive, and it turns out you're not for some reason. There was a mistake in the machine. You're still liable. So unfortunately, I think one has to accept that English law is generally very harsh, and there are specific places where it's particularly harsh. Now, what you would hope in that situation is that the police wouldn't prosecute because they have prosecutorial discretion. But in some places, we're very harsh about it. So it wouldn't matter if you were voluntarily or involuntarily intoxicated. There's actually a fun case on this where someone spiked the drink of another person at a party and was planning to tell them later, oh, by the way, it turns out accidentally you've been drinking alcohol. You can't drive home. Stay here with me. Didn't get round to telling them in time. They drove, caught, convicted. And at the point when the assessment was, should they lose their license? So it was deciding on the penalty. They were liable, just the penalty. The person who spiked their drink came forward and said, well, actually, I spiked it. Don't blame them. Okay, thank you, Sanjana. I'm afraid I've run out of time. It's been a pleasure to get to talk to you all. Sorry it's online where we can't really chat as easily, but I've really enjoyed getting to talk to you a little bit. I hope this has been interesting. There's loads more we could talk about. There's loads of really interesting things in the law course. I hope just in the time I've had, you've seen that it's interesting, that there's lots of things that you could contribute to as well, but there's also lots to think about. It's a really powerful, enriching, and large subject. And if it's the kind of thing that interests you, or even if it's not, I really wish you the very best of luck with what you do next. Thank you very much.
If you come along to the open days in June 28th, 29th, then we'll also be doing some lectures there as well. So if you have any more questions, you can definitely ask Matt then if he's there. Thanks so much, Matt. Okay, so next up we have our delightful sponsors. Clifford Chance are here. So we have Gemma Mills, who's going to do a talk to you about, like I said before, she's going to go through her career and how she became the person that she is with Clifford Chance, and to tell you more about Clifford Chance themselves and kind of where your career can go if you decide to take law as a degree, or even if you take a different subject as a degree as well.
So thanks, Emma, for the introduction. Like Emma mentioned, my name's Gemma and I'm an associate at Clifford Chance in our litigation and dispute resolution team. As you can probably tell, I'm working from home today because of the tube strikes, but we can work from home 50% of the time. So there's a good mix of being in the office and working from home. So I studied law at Oxford. I went to a state school in Stoke-on-Trent and attended a day very similar to what you guys are attending now. And then I did the unique summer school this summer at the end of year 12, and I did law at Teddy Hall for that. So I applied for Oxford in year 13, luckily got in and went to New College and had a really fun and really interesting 3 years. That it's definitely, it's an intense degree. There's a lot of work, but it's very rewarding and interesting, and the tutorial system is absolutely fantastic. That I got to have discussions with tutors about points of law that I never thought I'd get to pick the brains of such experts on. And just being at Oxford, you have so many bizarre experiences with all of the different traditions that it's just a really interesting 3 years, and it felt like you never knew what was going to happen because there was always something strange or exciting going on. So I applied for Clifford Chance's first year work experience in my first year and actually didn't get accepted. And then I met the firm at different events through the law faculty and our law society. So I was also on the committee for the Oxford Law Society. So met different people from Clifford Chance and just really got on with them. And I think I was told that one of the best tests for which firm you'd like to work at if you want to be a corporate solicitor is the people that you get on with. That everyone kept saying it's the people where if you're working late, who do you want to be having a chat with while you're making a coffee, who's going to make your day better or worse, you know, that if you're going to work a lot with these people and work very intense hours, and at times it's going to be stressful, you want people that you get on with where they'll make it better rather than worse. So I really liked the people that I met. I thought the things that they did sounded really interesting. And I also felt like the firm had a real commitment to diversity, whereas sometimes other firms, I felt like it was a bit more lip service, whereas I felt diversity was something that was really a core value at Clifford Chance. So I applied for the vacation scheme in my second year, prepared by doing the Watson Glaser test online. We had a competency interview, so I Googled a list of competencies and I would write down different examples of when I'd showed different types of competencies. So for example, it might be teamwork or time management, organization, things like that. And then we also had a case study interview, and I prepared for that by reading the news. That if you're interested in corporate law, you'll hear the phrase commercial awareness banded around a lot. And it basically just means kind of knowing what's going on in the world and the events and factors that might affect clients. So I prepared for that basically by reading the news. Did the interview and was lucky enough to get onto the vacation scheme. So that was a 2-week work experience program in the vacation at the end of my second year at Oxford. So that was a great 2 weeks. The firm even took us to Amsterdam for 2 days and 1 night to see the global network at play. And then at the end of that, I had a conversion interview and was offered a training contract. So a training contract is a 2-year program where you eventually will qualify as a lawyer. So every 6 months, so for 4 times, you'll rotate to a different department. So I sat in our corporate team first, working with financial institutions, that was insurance companies, banks, building societies. And then second, I sat with our disputes team. Third, I went on a 6-month secondment to our Abu Dhabi office and worked in our project finance and construction teams. And then for my 4th seat, I went on a client secondment to Amazon. So all very, very different, doing very different things and working with different clients throughout, but all really, really interesting. And then at the end of that, I chose to qualify into our disputes team because I really liked the nature of the work, the tasks that I'd been given. I felt like I really gelled with the team, and I just had a really enjoyable 6 months. That I liked all of my seats. I probably would have gone back to any of them, but disputes was the one that really stood out to me. So I qualified over the summer. So I've been there for, I think it's 6 months now, which has flown by, that I can't believe where the time since I graduated Oxford has gone, but it keeps going. So before I did my training contract, you have to do a course, and sometimes, so when I did it, it was called the LPC, and now it's called the SQE, and it's basically a period of further study where you do some exams and then you can start your training contract after you've passed the exams. So the firm pays if you have a training contract lined up before you start that, like I did, so I got offered mine at the end of my second year, then the firm will cover your fees for that course and they'll give you a maintenance grant to live on during that time. So it made it a lot easier and definitely relieved the kind of financial pressure of trying to become a lawyer when you have the firm to pay for the course and give you a maintenance grant. So in terms of things that I did to prepare for the application or when I was at your stage, I think legal work experience, especially meaningful legal work experience, can be really difficult to get. So we have some online virtual internships that are really great. We've got one aimed at students in sixth form, and I actually helped to design one of the tasks. So if you hate it, don't tell me. But it's a lot of different tasks that you might do as a trainee in different areas of the firm. So you'll get an insight into what it might be like to be in our corporate departments or perhaps the finance practice. And you'll get a realistic idea of what types of tasks you might do as a trainee. Otherwise, I would say coming to days like this are really important because you get to talk to different people. And I think ultimately no one becomes a trainee knowing that they want to be a trainee forever, because the point is that you'll qualify as a lawyer and then you'll go on to become an associate, and gradually you'll get more senior and more experienced and you'll do different things. So I think when I was in year 12, I did some work experience at a corporate law firm and I hated it because all I did was sit on reception, or I would do some like tasks that trainees had delegated to me. And I remember thinking, but this isn't what I want to do forever. And I think I missed the point, because the point isn't that you'll be a trainee forever. The point is that you should look at what the partners are doing, what the senior associates are doing, and think, is that something that one day I want to do? Is that something that I want to develop the skills to be able to do? And, you know, that's kind of more the end goal, or more of a realistic goal than being a trainee, because you're only a trainee for 2 years. And then otherwise, I would suggest just, trying to talk to as many people as possible. There's so many different podcasts or YouTube videos or online lectures where you can hear different people talk about different areas of law, or their careers or their career paths. So I think they're really, really good for helping you to work out what you want to do. But yeah, I would suggest keeping an open mind, because I nearly ruled out being a corporate solicitor based on 1 week of work experience, and I really love my job. So I definitely would not do that. But does anyone have any questions?
I was just wondering, are there any podcasts or anything like that you recommend?
Yeah, so our graduate recruitment team actually do some podcasts. So if you go on, I think the easiest way to find them might actually be on Instagram. If you go on the Clifford Chance, it's either graduate recruitment or Clifford Chance Careers Instagram page, then they probably have linked the podcasts in the bio, or on LinkedIn you'll definitely find them, and then you can hear different people from different parts of the firm talking about their careers or different cases. We definitely have trainees talking about like a day in their life, things like that, and talking about big cases that they've worked on.
Okay, thank you.
While you're studying law at uni, what sort of optional modules did you opt to take?
So I picked to do family law and medical law, which so at Oxford you can only pick, or when I was there, you could only pick optional modules in your 3rd year, and you could only pick 2. Or you could pick a mini option for jurisprudence as well. But that was like, you did that for about 4 weeks, I think. So I picked family law and medical law because whilst they have absolutely nothing to do with, well, no, that's probably not true. I was going to say they have absolutely nothing to do with what I do now, but there's always going to be cases that touch on elements of family law or medical law or things that I learned. So whilst they might not seem the most natural or complementary options for a career in corporate law, you learn the academic law that you need to know for the job on the LPC, and then you're always researching and looking up points of law as you go. So I think it's more important to pick things that you enjoy and things that you'll do well at, rather than thinking I should do these because they'll look good for corporate law.
Thank you.
Hi, Gemma. I just have a quick question. Is there a difference between having a BA degree or an LLB degree in terms of qualifying to go on to become a lawyer?
Yeah, I think an LLB is typically a law degree, although at Oxford you actually graduate with a BA in jurisprudence, but it's still a law degree. It's just classed as a BA, not an LLB. So I'm guessing you mean if there's a difference between studying law or non-law. And in terms of becoming a corporate lawyer, there's not particularly any difference. That about 50% of our trainees study law and about 50% don't. If you don't, you have to do a year of further study, which is, it used to be called the GDL, the Graduate Diploma in Law, but I'm not entirely sure what the course is called now. But basically you do a 1-year conversion course to kind of give you some of the knowledge and develop the skills that you would otherwise develop in a law degree. So I think when you're choosing your degree, you just want to choose something that you're really interested in. That you shouldn't choose to do law at Oxford because you want to become a corporate lawyer. If you're choosing law, it should be because you're genuinely interested in that as an academic study. You know, it's 3 years, it's intense. You do a lot of work. You don't want to be doing something that you don't like just because you want to be a lawyer at the end of it when you could do the GDL.
Okay, thank you so much.
So you mentioned that you did the corporate law experience. How do you actually go about undertaking and getting that opportunity? Because I've emailed so many firms, they've all rejected me saying they don't offer work experience to A-level students and only undergraduates?
Yeah, so I had definitely had that problem as well. It's just very hard to find any work experience. So I think that's why our virtual work experience schemes are really great, because they're open to everybody. And so we have the sixth form one, but then we also have a few different ones once you're at university. So when I applied for the work experience, there were a couple of firms that were doing work experience programs for students in year 12. So I applied for those that I think maybe Target Jobs and there were a couple of like websites that listed work experience schemes for year 12 students, and I just went on those and found the law ones. So I would just Google things like work experience year 12 law or something like that, and then some things might come up. But I know post-pandemic, I think a lot of firms have stopped doing that. I know we do a work experience program for students in year 12 called, I believe it's called Access, but if you go on our graduate recruitment website, then it will be on there. But otherwise, I emailed different barristers' chambers to see if I could do work experience at any of them. I managed to get a few days at one and sat on reception, so it wasn't very helpful. But at another one of the barristers actually phoned me and said they were really sorry that they couldn't give me any work experience, but he was happy to have a chat. So that was actually probably more useful than any of the work experience I actually had. So yeah, it can be really demoralizing when you can't find anything, but I wouldn't get too bothered by it, because everyone knows that it's so difficult to get it at sixth form, and you can do the virtual work experience programs.
Thank you.
Hi, I was just wondering, how did you choose whether you wanted to be like a barrister or a solicitor, or did you kind of just like fall naturally into the solicitor path?
So I always thought I wanted to be a barrister, and then it was not long after I got to Oxford that I realised that being a solicitor was probably more suited to me. So I think talking to older students who had done many pupilages and had more experience than I did, and talking to barristers and solicitors at different events that happened in Oxford was really useful for helping me to work it out. But ultimately, I think which might come as a surprise given that I'm talking to all of you, I really hate public speaking. So the idea of standing up in court and having to think on your feet that quickly is just so not for me. I would much rather be all over the detail, helping to draft the witness statements, the pleadings, all of that, than having to actually stand up and present the case and ultimately think on your feet when things go wrong so quickly. Not to say there's not thinking on your feet as a solicitor, there definitely is. It's just, yeah, the idea of standing up in court in front of a judge doesn't fill me with enjoyment. And I think barristers are self-employed and they work on their own a lot more, whereas I'm definitely a people person. I really like working with a big team, and going into the office where I see all the people I work with every day, and things like that. It was just, I think the nature of the work and the style of work is far more suited to me being a solicitor than a barrister.
What would you say the benefits and drawbacks of a law degree compared to a law conversion course are?
That's an interesting one. I think ultimately it comes down to whether you are interested in law as an academic subject rather than just wanting to be a lawyer at the end of it. I remember when I was in year 12, I watched a lecture about the law of adverse possession, which is this land law concept, and I just thought it was the coolest thing ever. So I realized that there were definitely parts of law that I was really interested in studying in depth, and that's what you get to do when you have the full 3 years, that you go into so much more depth in things than you ever could in 1 year. So you get the chance to explore things. With the tutorial system, you can really discuss things with your tutors, whereas when you're on the GDL, it's a lot more classroom based. That it's more almost like being, not necessarily like being back at school, but it's more similar, that you're not in small group tutorials, you're not discussing what you think about the law, you're just learning things about it. So I think I definitely, by doing law as a degree, was given the opportunity to work out what I thought and discuss that. The drawbacks, I guess I could have studied something else that I also found interesting, and then I would have still been able to study law by doing the GDL. So I guess if you have multiple things you're interested in, it gives you a chance to kind of pursue something else for a while before you go into law. But I did really enjoy having the 3 years to study law. So it's two-pronged. I think ultimately there's benefits and drawbacks to everything, and it's just whether the degree course, when you look at it, you think it suits you. So I like having all my exams at the end, that the Oxford exam system was far more suited to me, not having exams in second year. So I really had 2 years and a term to get to grips with my exam style and the subject matter. Whereas other subjects, I know you have exams at the end of second year. So I think it's thinking about things like that. But fundamentally, it does come down to whether you're really interested in law and whether you want to study it for 3 years in depth.
Thank you.
My question is, what is the most demanding part of your profession?
I think because we are ultimately a service provider, you know, we provide legal advice to clients. You are, to an extent, at the beck and call of your clients, that if something goes wrong, you know, if we have a client that calls the partner now and has just been served papers and they're being sued, then I'm probably going to have a late night. Or if something comes in like that over the weekend, you're probably going to have to pick it up. So there is the fact that you are just kind of at the beck and call of clients, but that also goes for a lot of other industries like accountancy or consultancy, that they're all quite demanding in that respect. But at the same time, that's never happened to me. I think it's pretty rare. So, I mean, there's times when there's lots of work and you might end up working late, or you might end up doing some work at a weekend. But the amount of times that something suddenly blows up is thankfully relatively rare.
Hi. So my question was, what sort of experience or work experience do you have before you started working with Clifford Chance?
So I did the Clifford Chance vacation scheme at the end of my second year. I did a couple of other like open days with law firms in my first year and my second year. And I did a first year scheme at another law firm in my first year, or actually, sorry, I did 2 different first year schemes. And then at school, I did 2 work experience placements with corporate law firms, and I shadowed a barrister for a few days. But I really don't think that experience is needed. That in my interview, people were far more interested in the fact that I'd rolled donuts and sugar at Alton Towers for 3 months one summer than they were in what legal work experience I had, because I think, like I said earlier, they know it's really difficult to get legal work experience, and often it's not particularly meaningful. You'll be, you know, sat on reception or you'll be doing admin, because that it's very difficult to give school students like interesting tasks, because if you think by the time you become a trainee, you've done so many years of legal study, it's difficult to then distill that down and work out what you could give to someone in sixth form to do. So I wouldn't stress about legal work experience. I think it's more important to think about what you already do, and like if you've got a part-time job, if you do any volunteering, the skills that you show through that. So you're already showing time management and the fact that you can juggle different things. You know, you've got your homework and your part-time job, or your volunteering, or if you play a musical instrument, or you're in a sports team, for example, or if you're in a sports team or a music ensemble, you show teamwork and that you can work with different people, and that you can cope under pressure because you have to perform when you're in a sports match or when you're on stage and things like that. So I wouldn't stress too much about legal work experience.
Okay, thank you.
Hi, I just wanted to ask what specific skills someone and knowledge can someone gain from the work experience, specifically targeted for year 12s and 13s?
So you'll gain an understanding of what a trainee actually does, which might sound like a silly statement, but I think it's actually quite difficult to work out what someone does day to day. That, you know, if someone asks me what my typical day is, I'll say I probably write a letter, I respond to a lot of emails, things like that. But I think by doing the work experience, you actually understand what that's like, and the types of issues that might arise, that it's just far easier to understand what it's like by doing it than by hearing about it. And you'll get an awareness of the different practice areas and our global network and how all the officers and practice areas work together. And then once you move on to some of the other work experience programs that we've got, there's ones focused on, I believe there's an intellectual property one, there's one about sustainability, I think there's a human rights one, there's lots of different topics. So you might gain more subject matter knowledge from doing those, but the sixth form one, you'll understand what it's like to be a trainee. So it'll help you work out whether you'd like to be a solicitor or a barrister, if you know you want to be a lawyer. And you'll get an awareness of the types of tasks that you do as a trainee and the types of skills that you need.
Hello, thank you. Yes, I wondered if you had any thoughts or your perspective on how artificial intelligence is changing the profession, and perhaps maybe your employers may have mentioned anything about pivoting towards its use, or have said anything about how it may impact the profession.
Yeah, so we use artificial intelligence it's built into like our word processing functions. So if I have a contract or if I have a witness statement, for example, there's always lots of different references to different paragraphs within the document. So you can put them in and it will automatically link and update, but sometimes they don't, or sometimes they break. So our AI function, for example, will flag where all of those cross references are, and it will flag which ones it thinks are wrong, or you can quickly go through and just check them all. Or it will flag when it thinks there's a typo, or where phrases have been written inconsistently. So if you say something in one way 9 times out of 10 in a document, it can flag that 10th time where it's abnormal, and then you can fix it and things like that. So there's lots of different word or ways it helps with long documents and using it in Microsoft Word. Then we have, so in disputes, we make a lot of bundles for court. So that's different, basically collections of documents that the judge might need to see or that the barristers will need to refer to. So we have different functions that make building those a lot easier, whereas historically it used to be done by like dragging pages into an Adobe PDF document and things like that. So we definitely use it. We're always looking at ways to use it more or to develop it to make everyone's life easier, because ultimately if I have to spend less time doing something, then the client gets charged less because they're not paying for my time, but it also means I can do something else, so we can take on more work and do a wider variety of work. So yeah, we're always looking for ways to use it. We already use it quite a lot, but I think often we get the question of whether AI will replace lawyers, and I wouldn't say, based on the AI I've seen, I would not say that's a risk.
Would you say that a GDL is any like less well regarded by law firms than a degree in law, or is so if someone's goal was a career in law, would a law degree be better in attaining a career in law, that sort of thing?
I think it depends if you want to be a solicitor or a barrister. If you want to be a barrister, I can see the advantages of having done a law degree rather than the GDL, because you know, we often go to counsel to advise on niche points of law, or they're the ones that ultimately stand up in court and have to write their skeleton arguments and dispute niche points of law. So I think the skills you develop through your law degree, and also the fact that you do have a more in-depth knowledge of a wider variety of areas of law, is more helpful if you're a barrister. But if you're a solicitor, I think, approximately 50% of our trainees do the GDL and 50% have done a law degree. So there's really no particular benefit to having done a law degree. I just would say, again, you want to do something that you're interested in, so, and you need to get a 2-1 for most law firms. So do a law degree if that's what you think you'll enjoy doing for 3 years, sorry. Whereas if there's something else that you think you would enjoy studying more, then I would say pursue that. But I really loved my law degree, so I'm a big advocate of studying law.
Thank you.
Brilliant. And with that, I think we'll have to wrap it up, I'm afraid, Gemma. Really short but sweet. If anyone has any other questions, they can send them to my email that I've been contacting you on, and I will try and collate them all and send them back out to Clifford Chance and get a few of those generalized questions, if that's okay. And just thank you very much for joining us this evening. I really appreciate it, and for the other 2 days that you came as well. Thanks very much. Okay, guys, so next up we have a seminar, or an idea of what a seminar would be, because a seminar would not be to this many people. So we've got Joseph Chu, who's going to join us, and he's a grad student and he will be leading you. So I'll let him introduce himself and we'll go on for the next 30 odd minutes-ish.
Hi, thanks very much, Emma, and welcome everyone. I know it's been a long day, so thank you all for joining us. So like Emma said, I will be running a seminar in a moment, and just to introduce myself briefly. So I am a graduate student doing the BCL, so that's the Law Masters here at Oxford University. I did my undergraduate degree in Arabic and political science in Abu Dhabi, and then I worked for 2 years in the consulting industry in the Middle East. And then I went back to Australia, where I'm from, and did my law degree. And then this past year, before coming here to Oxford, I was working with a solicitor and barrister. So looking forward to spending the next half an hour with you all as we go through this taster seminar. So the idea is that this seminar should be something that's interactive, with the opportunity for you to share your thoughts or ask questions. So at any point, if there's anything that you want to say or ask, then just raise your hand, and then we'll go from there. There'll also be parts during the seminar where I'll throw open the questions to you, and the floor will open to you, so feel free to speak up then. So the topic that we'll be talking about today is loosely termed the interactions between law and AI in cyberspace, with a particular emphasis on big data and how that affects our lives, and how the law, as we understand it today, can be used to regulate the use of big data and also mitigate the risks. So 3 main parts of our seminar today. Firstly, just talking about more broader questions about why we need law and what makes a good law. And then after that, we'll apply those answers that we get to 3 particular case studies with a focus on big data and how law can interact with that. And then at the end, we'll finish with an open Q&A where we can have a chat about the topic, or you can ask questions about studying law and other things that might have popped up during the day. So I guess I'll just start off now with this question, and this is an open question to everyone. So feel free to just unmute yourselves and share what you think. But what are some ideas if people asked you why you would need the law? Yes, Amelia?
Well, for me, I believe that the law is really overarching. Everything that we have and everything we do has some sort of legal framework behind it, whether it's a product or an action. It's so broad, and that breadth is so important that it's so fundamental to the society which we live in.
Okay, yeah, sure. So it provides structure to our society. Thank you, Amelia. Any other ideas, things that Sean, go ahead.
Protects the vulnerable within society, such as those who might not have their rights respected.
Yeah.
For a system like law.
Yeah, absolutely. Thank you very much. So the law has this function where you want to regulate power imbalances. So those who may have access to more financial or political resources won't use those to the disadvantagement or unfair disadvantagement of the others. Very good. Any other ideas? Why do we need law?
In terms of like the civil side, to settle disputes between multiple parties.
Absolutely. So disputes and conflicts are an inevitable part of human life. So law is used to regulate that. Very good. Thank you.
To uphold our commonly held moral values.
Yes, very good. Very good. So law is important not just for the functional aspect, but what it declares about what we hold important as a society. We'll take one more.
To act as a deterrent to crime before it's actually committed.
Yep, very good. So we want to tell people what they can do, what they shouldn't do, with the possibility of sanction and penalty behind that. So very good. Thank you, everyone. And sorry to those who weren't able to share. There'll be more questions later on, so you can definitely feel free to join with those. But I think we covered most of the things that I wanted to get at. which is thinking about why we need law, which relates to what does law do for us. So we talked about the regulatory function, so managing relationships between people and then between companies, which will be a big thing that we'll be talking about in a moment, and increasingly so also how we relate to the environment as well. Resolutive function, so helping people resolve disputes and conflicts as they arise in society, so we can have a better functioning society. And also the expressive function, so by deciding what's legal and what's not, and what may and how strong we might attach certain punishments to actions, we as a society are declaring what we think is important and what our values are. Okay, so keeping that in mind, right, we've talked a bit about why we need law. So why does this matter? Because it's all good to talk about law, but what is the interface with our daily lives? And which leads us to the next question, which is if someone to ask you, someone as people, wanting to study law, have this interest in this area, perhaps exploring it, how would you define what a good law is? What are some ways we can be thinking about that?
I suppose in terms of its effectiveness, as in if people obey it and rarely disobey it.
Yeah, okay. So how much it is upheld, how much people follow it. Very good, thank you. Yeah.
If it doesn't favor any particular one group in society over the other, like if it's fair. And
okay, yeah. So this idea about the fairness and balancing rights and interests. Very good. Thank you.
I think something that helps order and keep peace might make a good law.
Okay, yeah. So it's regulating, again, the relationships between societies, that there isn't chaos, there's a way to resolve disputes. Very good, thank you.
How extensive and thorough it is, as in if everything is defined correctly and makes sure that it involves as many people as possible.
Yeah, sure. So it has to be coherent, right? We have to know exactly what we're talking about. General laws, vague laws, which are hard to apply, aren't going to be very helpful. Thank you.
Yeah, something that isn't used to like indoctrinate or like is used as a form of propaganda to compel people to think a certain way as well.
Yeah, so we want to make sure that the law is coming with a purpose to help society as opposed to indoctrinate people in a certain idea. Yeah, thank you.
It meets the general consensus of society's needs and wants.
Okay, yeah. So now I think we're also touching on how we go about developing the law. Right? In many societies, the idea is that people should be participatory in the way that the law is developed. Thank you.
The adverse effects, it might not be as good as presumed.
Yeah, sure. So it's always thinking about the balancing act, right? So law helps us do this. It might also take away certain rights or have certain effects. So how do we balance that? Very good.
It creates a society where there is mutual respect between the state and its people, and this creates order and regulation.
Yeah, so law is kind of like that nexus between the state and government and the people who live in the society. Very good. And
it looks at different perspectives before making this final decision.
Yeah, very good. So going back to that deliberative, involving people in the process of making law.
When it's based on some sort of morals or ethics.
Okay, yeah. So the idea is that we want laws that are attached to morals and ideas that people can support. Very good. So thank you all again. I think we definitely covered a lot of those things there. So whether it works, whether it expresses what we think is important with values, the impact it has on people's lives, both the good contrasted with the maybe inconveniences or difficulties. And how we answer these questions is very important because these questions, even though they might seem a bit more abstract, they actually form the building blocks of how we form new laws, which is especially important when we as a society encounter new situations that previous generations have not encountered before. And the biggest example of that, one of the biggest examples in our day and age, is big data analytics. So has anyone encountered this term before and want to give a shot at explaining what they think this term means?
As I understand it, it's where you draw upon all kinds of psychometric data to discover trends in society and where sentiment lies, and to make more informed decisions rather than a sort of scattergun approach based on simple things like questionnaires and such.
Yeah, very good. So it's touching on the very important part, which is the idea of you're sourcing information from a lot of people. And today we'll be talking particularly about how companies take information from consumers and how they use that information about their preferences, about who they are as people, and then thinking about how the law interacts with that. And given what we've talked about why we need law and what makes law good, how the law might touch on these issues. So let's move on to our first case study. Anyone know what this is?
It's an Alexa.
Yeah, that's very good. So this is an Alexa. So it's the Amazon Echo Dot. So I'm sure some of you may have this in your house. Some of you may have this in your room right now. And so the idea behind having one of these things is that it makes life easier. You can talk to it, get it to set a timer for a few minutes. You can get it to start playing music. You can even get it to start ordering various things that you might need around the house. The first case study we're going to talk about is a patent that for software that Amazon actually put in back in 2017, where essentially the crux of the software is that it allows Alexa to be listening to you during the day for any audible features in your voice. So that could be things like if you're speaking to it and it sounds like you've got a sore throat, or if you're speaking to it and it sounds like you're emotionally quite strained or stressed. What happens then is that the information is taken through the Echo Dot and passed through the algorithm, and based upon how the algorithm decides your emotional or physical state, tailored ads will then be given to you. So for example, if I'm telling Alexa that I want it to set a timer for 10 minutes for whatever, say I'm cooking something, but it sounds like I've got a sore throat. If the algorithm picks that up, next time there's an ad, maybe between different apps that I'm using on Alexa, I'll get ads for cough syrup. I'll get ads for booking an appointment at a local GP to get things checked out. Or if it detects that I'm emotionally strained, it might offer and suggest a variety of services. So this idea is that it's always listening, it's always there, and it's listening into your life and trying to, based upon it hears about you, give you tailored ads and suggestions. So taking this as a case study, first of all, what are some good things about these technologies?
Maybe you could pick up if someone has like criminal intent and then report that.
Okay, tell me a bit more about that.
Maybe if like two people are plotting to rob a bank or I don't know, commit a murder, then Amazon could tell the police that and they can intervene and stop that.
Okay, so the idea that it can be listening in, I think the technology hasn't gone that far where we can tell that, but definitely I think this idea about getting more information about the people who are speaking. Thank you. Yeah.
It can increase the convenience of using an Alexa, as it can suggest things before you even think to search them yourself.
Yeah, absolutely. Right. The idea is that there are things that are out there that could be helpful for you, but you just don't know that they're there. So this could actually be matching you to that. Very good. Thank you.
It can increase sort of efficiency and productivity.
Yeah, tell me more about that. How does that? I agree. How does that increase productivity efficiency?
I mean, it can sort of automate routine or repetitive tasks, which allows us to focus on sort of more complex and creative tasks that couldn't be undertaken by it. So it ends up saving time.
Yeah, absolutely. Saving time. So instead of having to go online and then find something that you need, by having it suggest things for you, it can very quickly give you things that you need. Yeah, very good. So what about the flip side? What are some dangers of these technologies? So this technology, again, being it's listening to you and it's giving you suggestions about what it thinks that you might want.
It could probably breach like data protection laws and cause like complications for companies versus like governments and stuff.
Yeah, very good. So the idea that it's always listening and it's can't really decide what parts of conversations they can't listen to and what parts they can, that definitely raises issues of privacy. Thank you.
Invades and threatens personal liberty as it invades privacy.
Yeah. It's definitely quite invasive, right? I mean, like we have it in our living rooms where our lives are going on day to day, and so that can definitely be something that is a danger.
Quite a similar point, but there's the issue of whether or not anybody who buys an Alexa has consented to them being listened to 24/7.
Yeah, very good, very good. So most people buy an Alexa because they know it's fun, they know it's efficient. Very few people might actually know what it's actually doing behind the scenes. So this idea of consent.
It might lead to over-reliance on technology and a lack of natural incentive from humans.
Yeah, sure. So there's the idea about we might be relying on this too much, that we might not be able to do things ourselves.
Yeah, so the information that is gained from the Alexa could be used to give into third parties like other companies such as like Amazon, Facebook.
Yeah, very good. So the idea is that it's not just about who's collecting it, but how that's being used and who that's also being passed on to. Very good. Thank you all. I think those all canvass very well the dangers and both the benefits of that. And then leads us to this next question about how is it that we can use the law to manage the dangers without getting rid of the good? general principle?
We could restrict the third parties that the data is allowed to be shared to.
Yeah, so having laws that require that companies which maybe get certain data can't just pass it on. Yeah, very good.
There is EU law, the GDPR.
Yes.
Which means they can only hold on to that data for 2 years, I think.
Yeah, so requiring by law that companies need to get rid of data after a certain time. Yeah, very good. Yeah.
They should ensure that customers are aware of these laws and features of the products.
Yeah, absolutely. Very good. So making sure that what the features are being communicated to them. Very good. And yeah.
It kind of links into what the previous person said, but you could have a sort of opt-in scheme to the always listening part of it.
Yeah, yeah, very good. And so it's the idea that not only is it communicated, but also you have the option to consent to it, or vice versa, to not consent to it. Very good.
You can establish like liability framework that kind of holds the developers accountable and ensures that any harm caused is down to them, not you.
Yeah, absolutely. So we want to make it so that if there is issues with it, that there is some form of sanction so that the collectors of information, those who use it, have an incentive to make sure that they're using it according to how the law requires them to. Very good. So let's keep all those answers in mind as we move to a slightly different example. So this here, of course, we would all know is Google Maps. And the second example has to do with a feature called Google Maps Timeline, which actually, if you have it switched on, tracks the places that you go, when you go, how often you go, even what options you choose to use to go to these places. And then over time, you can actually construct over the years where you've been. So it's actually a bit creepy, but you go online, it's this function, you can even just search it up and see if you've got it activated. But it basically shows all around the world, the places you've been to, the types of venues you visited, maybe restaurants you've eaten at, and how you've gotten there and the time when you went. And this one combined with your other data online, which is a part of your Google account, can be used to construct an entire virtual profile. So basically our lives as they are imaged through the way that we use technology is all tracked and then kept online. Similar questions again. So with this one here, what could be good about something like this?
So in cases of like missing persons, if you're able to refer to someone's Google timeline and you can see like their normal day-to-day lives, you might be able to predict where it is they might go.
Yeah, absolutely. That's a very good point. The idea that, given this person's routine, they usually go from this place to this place. At this time, they've got a missing. Where possibly could we be searching for this person? Very good point.
Along a similar vein, you can check someone's alibi in a criminal case, or could it like create an alibi through that and validate it through that process?
Yeah, absolutely, absolutely. So having that information on hand lets us know what the person has done or what they haven't done. Yeah.
It can be quite convenient for the consumer. For example, if you go somewhere at a certain time every day, they can give you the directions if at that certain time.
Yeah, yeah. So if it knows what your familiar patterns are, it can be giving you suggestions. Yeah.
A profile it creates of you might be highly personalized, so be quite like related back to you.
Yeah, it can even give you suggestions like, you've over these last few years, you've gone to these sorts of cafes and you're in a new area and you could try this and out. Yeah. Same question again. What are the dangers of this one? And thinking specifically, is there a difference between this and what we saw before with Echo Dot?
It's not quite a danger, but I'm not really quite sure how this works, but I assume it goes off the location of the phone. But it doesn't really account for example, people giving their phone to other people and then they go on this, there's a small anomalies maybe, but they could be important.
Sure. So it could just be that the technology that's meant to be used to help us personalize our the things that we get might not actually work out because there's some other things we haven't taken into account.
It can violate the privacy which certain people want to have.
Yes. Okay. So similar to Echo Dot, but in this case, it's not the voice; it's about where you're going and what you're doing. Very good.
I think definitely it's similar to the Alexa, but the level of intrusion is a whole different thing because it knows your exact location. For example, the Alexa certainly knows your current state, but this is something completely different because it's exactly where you are.
Yeah, down to the dot. Very good. So there's a different level of privacy about our location and where we go as people. Very good.
If there were a leak of information, who would be responsible?
Yeah, very good. So again, it's not just who's collecting the information, but whether that information is secure and what type of other parties might end up taking it and what they might do with it.
I was possibly thinking that if someone could have access to your Google account, then they could see all your location data, and that could be very dangerous, especially if you're a minor and you're on the internet and you're giving out like your access to your Google account to strangers. They could just like stalk you, see where your school is and stuff like that.
Yeah, absolutely. There are a whole host of dangers there. We've talked already a bit about how the law can manage these dangers, and I think it comes back to a few different points of communicating what people are signing up for, making sure there's options to consent or not, and then making sure the information is kept secure, which is the next point that we want to touch on, and something that Aidan alluded to just then. For our third case study, does anyone know what the 8-4 rule is? I don't expect you to. I didn't find this out until I was preparing for this. The 8-4 rule. So the 8-4 rule is a rule of thumb that people use to set secure passwords. So idea is that you've got 8 characters minimum with 4 particular things: 1 lowercase, 1 uppercase, letter, and then 1 number and 1 special character. Some people also do the 16-4 rule as well, where you have 16 minimum characters. And then there's other rules about not using the same password between work and home, not sharing things between financial institutions and your social accounts. And then, of course, not telling anyone your password. Talking about this because this has to do with security. And we want to protect our data because if it gets leaked out, as Aidan said before, it could seriously affect our lives and the lives of the people whose data it is. Anyone encountered these things before and want to share what usually happens, why these things happen, and how do you get around it?
So sometimes if you're trying to sign in, especially on a device you might not have signed in on before, you get a notification to your phone and it kind of says like, can you verify that it's you? And I know a lot of institutions like Microsoft, they also have authenticator apps now. So there's like a double step process to logging in. So before you log in on your laptop, you have to approve it on your phone.
Yeah, very good. Yeah, so this is thank you for that, Beth. So the idea of the two-factor authentication, which if you're logging in from a different device, or if for those of us who may be going traveling every now and then, if we're logging in from a different location, it's usually asking us to provide some form of authentication. Does anyone think, so taking this one here on the right side, does anyone see any potential issues with what is being asked here and this entire idea of two-factor authentication?
I know there's a problem with phishing, where people can send the emails from a different email address, like the same posing as Microsoft, and then they can receive the code that the user enters in, and then they can log into the client's the user's account.
Yeah, absolutely. So there's always ways that that could put this at risk. Yeah, very good.
Well, I'm assuming this would be a minority of cases, but there can just be instances where it's just inconvenient for the person. For example, their phone has died and they need to sign in on a certain device and they're unable to confirm it on their phone, or if their phone is broken and they really, really need to sign on to something or something like that. I accept there'll be a minority of cases, but it still would be inconvenient for the person involved.
Yeah, so there could be the inconvenience, definitely.
The way they're affirming it on the left-hand side is by viewing your recent activity. I don't know if it's important, but it just shows they've been watching it and they're paying attention to it all the time.
Yeah.
And it shows that people have been monitoring your information, and that's how they figured out that there's been unusual activity.
Yeah, very good.
I think we can see that on the right-hand side. It says provide a phone number, not necessarily saying the phone number you signed up with, showing that anyone, anywhere could literally put in their own phone number and claim to be you.
Yeah, very good. And so there's definitely the risk of people, again, coming in and faking it. There's also, even if it actually is you, right? The idea of this two-factor authentication is we want to keep our data and information private. But in this case, it's requiring you to give more information about yourself to protect data that you supposedly want to keep secure, which I think touches on this idea that it's just very hard to keep our information secure. So let's just think about that. So we've talked a bit about the how the law can be used to regulate these things, right? So making sure there's consent, there's communication of what people are actually signing up for, and making sure the data is encrypted and kept secure. And that's something that we can use the law to attempt to do. What are some potential challenges that the law might face when we try to do this, given what we've talked about?
Well, I was thinking about press intrusion, that, you know, they have hacked into people's phones and they'll use the public interest as a defense. The Levinson inquiry.
Yeah, sure, thanks.
If there was an issue in which someone had to verify their identity, but their device got stolen and someone else did that, how do you prove that it wasn't the true owner who verified it? How do you prove it was someone else because it's, authentic to that one person's device? Yeah, that's right. So there's just a lot of evidentiary issues, right? Once we start doing things online and offline, it's hard to tell where the lines can be drawn. Yeah. What about thinking about like these companies? These are all like Google, we've talked about, we've got Microsoft here, and Amazon. What about thinking about how the law can relate to these companies? What are some potential challenges of wanting to make sure we have consent or communication or sanctioning bad behavior by these companies?
I mean, often there's sort of jurisdictional issues because many of these companies have bases in separate countries. So often say where it happened in the UK, you couldn't like enforce what was going on wrong if the base was in, say, like America. Right. Yeah. Thank you. Yeah. So there's jurisdictional issues. Anything else?
Maybe the fact that you're voluntarily giving the information, it's not forced.
Yeah, so many people may, when we say we consent to things, we might not actually know completely what we are consenting to. But in general, Commonwealth law holds that when we say that we consent to things, unless there are terms which are completely out of the ordinary, we've consented to all the things that we say. Yeah.
Maybe responsibility, because if your phone is stolen, these organizations can argue that it's no longer their responsibility because that was your responsibility. So even though it was set up for, protection so that only you can access your account, it kind of can like blur the lines a bit, I guess.
Yeah, so similar to what we was talked about before. Very good. Yeah, I was clicking back and forth in my slides a bit because I was trying to look for this one image that I had, but I don't have here. Another issue we have with thinking about the way that the law works is that if you recall what we were discussing about a few minutes ago, it was that we need the law to be able to be effective, it has to be able to be enforced, and it has to have some sanction behind it. So the parties have actually incentive to obey it. The problem with many of these companies is that they're extremely wealthy. So if you go online and just compare the net worth of many of these companies to countries, there are, I think, all of like Amazon, Microsoft, Apple, all of them have a net worth higher than the GDP of Australia, where I'm from. So that throws in all sorts of issues about if you're trying to enforce a law against them, how can you make it so that the sanction that parties will receive for doing things wrong will actually be something that motivates them to do what the law requires, which is, I think, another issue. So wrapping things up, so the purpose of the seminar today was trying to think about what is it that we try to use law for, and then what makes a good law, and then trying to relate that to new situations we're finding ourselves in. And I think especially for our generation coming up, big data and the way that data is collected and used will be something that we'll have to grapple with, and to see how the law interacts with these things. So I guess three main takeaways here as we finish our time is thinking about how everything is interrelated. So all our information and the way that we do things online is all kept and stored, maybe across different accounts, but they can all be compiled together for one digital identity. So how does that affect the way that we think about how law should regulate things that companies do? And not only are we interacting with companies, but there are also many of them. So companies are not just the ones collecting, but they're also the ones sharing, also ones selling, and also ones using. And all of these things make the decision of what makes a good law to deal with these issues all the more complicated. So that's a taste of what a seminar might be like. So thinking about just what the law is, how it relates to new topics and issues that we're facing in our societies. That's what we had today for in terms of substantive things. Questions, not just about the topic, but about studying law or experience in Oxford in general. Yeah.
Thank you for this like mini seminar that you've given us. I do have a question. Do you have any like extra material on stuff like law and AI being linked together?
I do. So one of the courses that I'm doing in the master's right now, we have a module on how AI is actually affecting both things we talked about, so information, how it's processed, but also how the law is actually being used. So there's new technology nowadays, which essentially you put your situation into a system and the algorithm looks at past cases and how they were decided and gives you some predictions about what the likely outcome is. I definitely do have some articles that I've read. I can't remember the names off the top of my head, but we can try to find a way to get that to you if you're interested in finding out more.
What would you say sets Oxford apart from like other universities for law?
I think there's several things. So it's maybe not as first one is not unique to Oxford per se, but the tutorial style of teaching gives you just unparalleled access to tutors, many of whom are at the top of their field. And so the opportunity to meet with them regularly, have your questions asked and answered, and even as have the things that you write taken really seriously by these people who are at the top of their field, I think really gives you a rigor and depth that is hard to find in other universities. I think another thing that sets Oxford apart is the fact that it's a place where people from all around the world come. And so you've got people who are at the top of their field coming, not just to teach classes, but during the week, there are various lectures, discussion groups, research opportunities, which you can get be a part of even as an undergraduate, which just allow you to increase your network. So there are some people that I've met here who I've never taken classes with, but I just happened to go to a lecture that they gave. And through those conversations have become really meaningful interactions. There's that. And I think just the amount of support that you get as a student here and the access to faculty and resources through the college system definitely sets the university apart. I'm sure there's many others, but those are just a few that I could think of.
How important would you say it is that you have strong political and historical background knowledge to understand the English legal system? And do you have any recommendations on familiarizing with that for international students who might not be so familiar?
Yeah. So the program I'm doing, the BCL, there was a sister program called the Magister Juris MJUR, and that's for students who come from a civil law background. I think there are, when you come to to study here, I think many of the things you will be taught from scratch. And I think another benefit of having many tutorials and access to professors is that you've got the opportunity to kind of fill in the gaps in your knowledge. I would say, I think many of the things that are needed will be taught within the first few years. And then if you feel like you're needing particular help in certain areas, the faculty are always very happy and your tutors are very happy to help you with that.
Thank you.
Yeah. Chantal?
So Oxford has many colleges.
Yeah.
During the application process, do you have to choose one you want to go to? And is there a better or worse one for studying law? How does that kind of work?
Yeah, so I can only speak about that from my application as a master's student, but as far as I know, you do put preferences in for colleges, and then there's a process in which after interviews, basically you'll get allocated to particular colleges. I think all of them, all of the colleges have a variety of various tutors who you'll be able to receive help from. I think some colleges in particular might have dedicated law libraries or resources, but I wouldn't necessarily say from what I know that there are particular colleges where if you want to study law, you shouldn't apply for. That's not something that I've heard of.
I'll just step in there and say from admissions officer point of view, yes, so you can either choose a college or you can do an open application. And we've changed the way that we do our system recently, the past 3 years now, that we do college blind shortlisting. So actually, there's not that much importance in choosing your college. And we always say as well, don't get your heart set on a college, because there's every chance that you'll be reallocated throughout our shortlisting and interview process. So you would be moved to a different college. So yeah, whilst it's good to know what's available, you don't get your heart set on anything.
Thanks, Emma. Thanks for stepping in there.
My question was, you mentioned that the things you write are taken seriously. So I was wondering, what type of essays do you write and on what topics?
So from what I know, it's usually, well, from my experience, it's usually something that's related to the topics that you've been reading throughout your course. So there might be readings on a particular issue in law, and then oftentimes the tutorial questions either will get you to express your opinion, or there might be like a problem question getting you to deal with a certain issue. So I was talking to a friend who is in their second year of the undergraduate degree, and their recent tutorial question was, is judicial discretion something that is avoidable, or will it always be there? So there's sorts of things where you have an opportunity to give your thoughts on a topic, and then the tutor will have a read of that and actually engage with the arguments that you're making.
Okay, thank you.
Yeah. How are we doing in terms of time?
Maybe just until 1:15, and then they can ask any questions, they can email them in. But yeah, I think we can take maybe one more question.
Yeah, sure. Yassine?
Hi, I just wanted to ask what you found most challenging during your law degree.
I think one of the things that I definitely find challenging is that because in Oxford specifically, there are so many opportunities. So not just in your study, but also things like getting involved in discussion groups, going to other seminars, getting involved in student societies. There's a lot of different things that you could do. I think one of the challenges is just finding how you balance the time. I think with Oxford, it's not trying to find things to do, it's trying to decide which things to do. And I think that's definitely a challenge, but it's a good challenge to have because it shows that actually that you have so many opportunities and resources at your fingertips. And I think this is something that as the degree goes on, as we settle and find our feet as students, we're able to decide what it is that we want to invest our time in and what we find most meaningful to do.
Thank you very much, Joseph, for joining us tonight. I know it's quite a late one, so I really appreciate it, and I'm sure everyone else does. So I'll just throw one thing out there. So this has been a taster for law at Oxford, obviously, but also to get you into law if it's kind of something you were maybe on the fence about. But if you want to speak and see the rest of the university, and obviously you couldn't come this time, you're very welcome. The university is open on the 28th and 29th of June for our open days. And that's basically the whole university takes part in it. So all the colleges will be open, all the faculties, all the departments. Oxford comes alive on those days. So you're welcome to come along. There's no booking, there's no registering for law events. We will have another taster lecture, and we'll also have ambassadors around as well. So you'll get to speak to undergraduate students who are currently in their second year usually. They're so happy to talk to you about every aspect of college life, of law life, of everything that is Oxford. So please do come along. They're really great events. It's 2 days in June, and then we have another one on the 15th of September as well. And really, this is your opportunity to see behind all the walls and the closed doors that usually only tourists ever get to see is just the door. This is a chance where everything is open to you. Chance to speak to post holders as well, not just in our subjects. If you go to the colleges, a lot of the post holders will be there and will have one-on-ones with you, and you can talk to them about anything you like. So all that's left really is for me to say thank you very much for joining us.